Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hola, y'all. So this week, jury selection has been underway. I said underway, underway, in a lawsuit accusing Dallas Cowboy owner Jerry Jones of sexually assaulting a woman from South Carolina, Janie Green, after a cowboy game, a cowboy, cowboys, Cowboys game in 2018. This lawsuit has been going on since 2020. Y'all, when I tell you I have been scrolling through this case for the past couple of days, and I'm now, y'all know I also do personal injury. So when this will be we take it like a personal injury case. I'm just going to put it out there. So I'm on the plaintiff's side. So in this case, we would be representing Miss Janie Green. As a person who has done intake, has gone through, done pre-litigation, litigation, and helped with trial, attended depositions, mediations, and things of that nature. All I gotta say is, I don't know. And this is my opinion based off of the facts that I have read in each side's complaint. I don't see it. But I'm going to put this out here so you all can be the judge. I'm Cassandra, aka your favorite paralegal, and this is Legal Doc Talk. So today we're going to be talking about one of the biggest civil trials in sports. Nobody's really covering it, so I don't know what's going on. But this one has been in the years of making. As you can see, I have on the screen Jerry Jones. His name is I was like, well, that's his real name, but that's neither here nor there. He filed a no evidence motion in traditional for summary judgment. And usually in a summary judgment, this is submitted to the judge for them to decide versus having it go to trial with the jury and so on and so forth. We're going to get into what happened to this particular one. But before a single juror was called, before opening statements, before witnesses took the stand, this that you see on your screen was Jerry Jones' final attempt to stop this case from ever going to a jury. They filed, as you can see, it's 200 and how many pages? 294 pages. And in this, I'm not going to scroll. I'm going to scroll to a certain point. You know what? Hold it. Let me. I'm going to scroll to. I'm going to put this on here because y'all. So, what you see on here is the timeline of the photos, the time that she said the incident happened, this red part right here, and then the photos that she took after the said incident happened. The alleged as and I'm just going to keep this on the screen. Hopefully, y'all can look at the time. Y'all be the judge. I already gave my opinion. But as a plaintiff, personal injury, paralegal, we have to we yeah, we have the burden of proof. So this is crazy, y'all. Attorneys have withdrew from her case. It's like a revolving door, but that's neither here nor there. Let me get back on schedule. They argued that the evidence was so overwhelmingly in Jones's favor that no reasonable jury could rule for the plaintiff. I'm going to repeat that. In this motion for summary judgment, now mind you, it is for on behalf of the defendant. They argued that the evidence was so overwhelmingly in favor of Jerry Jones that they felt if it gets to the jury, then it's not going to be favorable for the plaintiff. I have worked with firms that has gone to trial and left with nothing. Attorneys' expenses are not going to be paid. So all of that money that you did for pre-lit, during litigation, for trial, depositions, getting transcripts, experts, mediation, uh, you name it, you don't get any funds from that. You have to eat those costs. So you definitely want to ensure, and that's why, and I'm not trying to knock anybody's case down, but when you call these firms, it doesn't matter if it's a solo practitioner or if it's a larger firm, you have to understand the plaintiff the blah blah the plaintiff has the burden of proof. They have to prove up, they have to have evidence, tangible, whether audio, video, photos, witnesses, whatever the case may be, to prove up what you're the claims that you're saying in this petition. All right. But anywho's, we're going to break down exactly what the motion argued, why the defense believed that the case should have been dismissed, and importantly, why the judge denied this motion that you see on the screen, allowing this lawsuit to move forward to a trial. Let's get into it, guys. So, to kind of make everything flow here, let's talk about what a summary judgment motion really is. So, for a lot of people, they hear the term and assume it's basically a mini trial, and it's not. A summary judgment motion asks the judge to decide that there is no genuine disputes over important facts, meaning there's nothing left for a jury to decide. If the judges agree, the case ends. No jury, no witnesses, no trial. Jerry Jones filed both a traditional and a no evidence motion for summary judgment, arguing that the plaintiff lacked sufficient evidence to support her claims. Now, the very first pages of this motion actually set the tone. Jones' attorney argues that this isn't simply a weak case. They argue it's an impossible case. The motion repeatedly claims the plaintiff's version of events could not have happened based on the photographs, the witness testimonies, and electronic device. That's a bold argument. So, what evidence were they relying on? All right, let's look at the timeline. So, according to the defense, photographs, as you can see on the screen, taken that night include metadata showing the exact time they were captured. The motion states the photographs with Jerry Jones were taken around 12:48 a.m. Then approximately 2 minutes and 31 seconds later, the plaintiff was photographed smiling with former Cowboy linebacker Jalen Smith and her grandson. The defense argues that within those 2.5 minutes, the plaintiff claims all of the following occurred. Now, listen to this. 2.5 minutes, she's saying the alleged assault occurred, walking to another room, comforting her grandson, speaking with family members, gathering everyone to leave, and posing for multiple photographs. The defense says that's simply not possible. Of course, that's the defense interpretation of the evidence, not a judicial finding. Second argument that they're making, they are emphasizing exactly where the alleged incident happened. According to this motion, again, the event took place in a crowded VIP area with hundreds of people nearby. You have players, coaches, security, photographers, guests. Jones' attorney, they argued that none of the witnesses identified by the plaintiff confirmed seeing an assault, and they cite testimony from multiple individuals who said they did not observe inappropriate conduct. Again, these arguments presented by the defense for the court to consider. Another major section focuses on the plaintiff's deposition. This is argument 3. Y'all, I read the deposition transcript, and I'll tell you, side note, when we prepare plaintiffs for depositions, we do about a week or two in advance, possibly a week, because we want it to be fresh on their mind, or even like within a week, 2, 3, 4 days at most, right? And we prep them on what not to say, what to say, how to respond to a certain question that opposing counsel asks, right? Sometimes they do not take our advice. They do not. And what happens when they don't take our advice? A lot more things that even we didn't know comes out because they're running their mouth. But anywho, I digress. Let's get back into this next one. So the plaintiff's testimony in her deposition. Jones's attorney argued that she could not describe certain details of the alleged encounter, including specific aspects of the physical contact they believed were important to proving her claims. The motion contends those alleged inconsistencies prevent her from establishing the essential elements of assault and battery. Now, whether a jury agrees with that interpretation is another question entirely. And I give y'all an example. One, she alleged that, and if y'all are unaware of what's going on, she alleged that uh Jones actually assaulted her by pushing at, like, after they took the picture, she claims that he took her, like placed his hand behind her and pushed her into him, and he kissed her. She said his tongue was all in his her mouth and whatnot, right? And I'm only laughing because of the way I'm picturing this story. I'm not laughing at the situation, I'm just laughing at the story, so forgive me. In that time, in the deposition, when they asked, they was like, well, did he stick his tongue? Because at first she said, well, my mouth was closed. And then they said, well, I thought you said that he stuck his tongue in your mouth. How did he stick his tongue in your mouth if your mouth was closed? So on and so forth. Then they talk about how she didn't drop any of her things. She had a phone, she had a badge, she had probably like 4 or 5 things in her hand, and she claimed that she threw her hands up in the air after it happened, but she didn't drop anything. So those are the things that they really, and I probably will pull the deposition transcript and have, because it's attached in here, and we'll go over that probably in a members live. But this right here is very pivotal, pivotal, can't even talk, to the case. Like, you're claiming one thing, but you have no evidence to back it up, to prove up your claim. The fourth argument. The defense also spends dozens of pages discussing the plaintiff's action after the alleged incident. According to the motion, she continued taking photographs, did not report the alleged assault, that night to law enforcement, and later shared photographs from the events with others. That's what you see on the screen. The defense argues those actions are inconsistent with the allegations being made in the lawsuit. Again, what is the defense argument? The plaintiff disputes the defense's characterization of evidence. And let's talk about discovery. All right, that's argument 5. The motion shifts away from the alleged allegations and it focused on what happened during the lawsuit itself. Jones's attorney argued that the plaintiff repeatedly failed to comply with discovery orders. The motion referencing court orders compelling production of cell phone data and metadata, motions to compel, sanctions imposed during discovery. And when sanctions ain't going towards her, sanctions is going towards the attorneys. That's the reason several tried to escape this lawsuit. And ongoing disputes regarding forensic examination of electronic devices. It makes our job very, very, very difficult if you're not willing to help us help you. If we're asking you to give the cell phone so we could pull all of the data from it, or have a forensic specialists, pull the data from it. How can we help you? You got to work with us. You came to us seeking. This is not something that you can just file a lawsuit and get money the next day. No, you actually have to prove up your damages. It's not as easy as everybody makes it seem. And it's not a quick process. Every case is different in its own way. But when you make it difficult for the attorneys to do their job to represent you, how can we move forward? So the big question is, why didn't the judge dismiss this case? I mean, come on, there's no sufficient evidence that says that Jerry Jones actually committed these crimes. You know what I'm saying? But here's the part everybody wants to know. So if the defense presented this whole motion right here, almost 300 pages of arguments, why are we having a trial? And that's because the judge denied this very motion that you see on my screen. That ruling is extremely important. Now, a denial, right, does not mean that the judge believes the plaintiff. And it also doesn't mean that the judge believes Jerry Jones is liable. Instead, it means that the court determined that there are factual disputes that should be resolved by a jury rather than decided by the judge before trial. That's a crucial distinction. Judges decide legal questions, jurors decide disputed facts. The judge's ruling simply means this case met the legal standard to continue to trial despite the defense's request for dismissal. Now comes the phase we've all been waiting for, jury selection. Both sides, and I'm assuming that they did, will question potential jurors. Each side will attempt to remove jurors based on if they believe that they cannot be fair. Once the jury is seated, opening statements will begin, then witnesses, evidence, cross examination, and ultimately a verdict. The jury, not the judge, will determine whether the plaintiff has proven her claims by the applicable civil burden of proof. No matter where you stand on this case, one thing is clear. Jerry Jones' attorneys made an aggressive effort to end this lawsuit before trial. They argued the evidence proved the allegations were impossible, not weak, but impossible. The plaintiff argued otherwise. The judge decided those, you know, competing arguments should not be resolved on paper. Instead, 12 jurors will hear the testimony, examine the evidence, assess the credibility of the witnesses, and decide the facts. And that's why, after years of litigation, this case is finally headed to trial. As always, I'll be covering every major development from jury selection through the verdict. So if you are interested in legal news and high profile court cases, make sure you just subscribe to my channel and turn on those notifications in case I have another video uploaded or I go live. You will be notified. And I also like to hear your guys' thoughts in the comments below. Like, do you think that the judge made a right decision by allowing this case to go to trial, or do you think that she should have just granted this motion for traditional and no evidence summary judgment? Put y'all thoughts in the comments below. Don't forget to like, share, and subscribe, and I'll catch y'all in the next one.